Welcome back to the Deep Dive. Today we're taking a pretty dramatic turn into one of the most, well, agonizing corners of criminal law. We're talking about the defense of duress.
It's a fascinating topic. It really is. Because it's where the law has to get real about the limits of, human endurance. We're basically asking how much fear, how much absolute terror does it take to legally excuse a crime?
Exactly. And we're narrowing our focus to the ultimate dilemma, duress. But when the crime is homicide, we're looking for those aha moments. How does the law balance punishing a killer with understanding just pure survival-driven desperation? If someone puts a gun to your head and makes you help them, are you a murderer?
And our mission today is going to be really analytical. We have to dissect the doctrine of duress, which sounds simple, but it comes with this huge, powerful limitation when an innocent person dies. Then we'll get into the really nuanced part, the idea of mitigation, this concept of imperfect duress that can knock a murder charge down to manslaughter. And that means a really rigorous step-by-step look at the case law.
Okay, let's do it. Let's start with the basics. Before we even get to murder, what is the black letter rule for the duress defense in general?
Right. So the general rule is that duress can be a total defense for, well, almost any crime. A defendant has to show they were under this compelling force, this coercion, specifically an imminent threat of death or serious bodily harm.
And they couldn't just run away or call the police.
Exactly. There had to be no reasonable opportunity to escape. It's a high bar. The threat has to be something, a reasonable person just couldn't resist.
Okay, that makes sense. A recognition of basic human fear. But now let's get to the heart of it. What's the massive limitation that kicks in the second that crime becomes the murder of an innocent person?
This is the immovable point in the law. It's a bright line rule, really, coming from cases like Frasher v. State, and it's simple. Duress is not a defense for taking the life of an innocent person, full stop.
Let's just pause on that for a second. That is an incredibly harsh moral stance. The law is demanding that you choose to die rather than kill another innocent person. Why is it so uncompromising?
It really gets to the core purpose of criminal law, which is, maintaining social order and protecting the innocent above all else. If duress were a total excuse for murder, it would essentially legalize killing someone to save your own skin. It just undermines the whole idea of the sanctity of life. The law demands a kind of superhuman courage here.
That distinction is so critical, the demand for self-sacrifice. Okay, let's put this rule to the test with the facts of Anne Louise Wentworth v. State. This case is perfect because the coercion was so clear. So first, what are the legally dispositive facts?
Okay, so Anne Wentworth and her husband, David, are visiting a man named Mosley. Things go south, fast. David pulls a gun, accuses Mosley of adultery. Anne confirms it. Then, under David's orders, and he's described as furious, maniacal Anne has to find bullets and load the gun. Later, she starts Mosley's car, wipes fingerprints, all while David has Mosley at gunpoint. Anne testified she was, and this is a quote, deathly afraid that she thought they were both about to be killed. Mosley was later found shot dead.
A terrifying situation. So what was the core legal issue for the court?
The precise legal question was this. Could the defense of duress act as a total exculpation? A complete defense, an acquittal for Anne, given that she participated in the felony that led to Mosley's death.
And what rule of law did the court pull out to deal with that question? Can you state the rule and break it down into its testable elements for us?
Sure. The court went straight to that limitation from Frasher. The rule is, duress is a defense to all crimes except when the result is taking an innocent person's life. So to analyze that exception, you're looking for two things, two elements. One, was the criminal act actually committed under duress? And two, did that act result in an innocent person's death?
Thank you. Okay, now for the court's elemental analysis. Let's go step by step. How did the court handle that first element? The act was committed under duress.
Right, so this part is just about the coercion itself. And the court found, there was compelling evidence of duress. Anne testified she was deathly afraid. Her husband was paranoid, irrational, on drugs and alcohol. Crucially, she knew he'd been violent before he'd even attacked her father. So the court's conclusion on this sub-issue was, yes, the evidence for duress was strong. This element was clearly met.
Understood. So a genuine imminent threat existed. Now for the crucial part, what about that second element? The result was the taking of an innocent person's life.
This one was just as clear, unfortunately for her. The victim, Mosley, was an innocent third party. He wasn't the aggressor. And Anne's actions, loading the gun, starting the car, wiping prints, that was direct participation in the crime that led to his death. So because an innocent person died as a result of the chain of events she participated in, this element was also met. The exception was triggered.
So after analyzing both of those elements, what was the court's final conclusion about a total acquittal for Anne?
The court concluded that because of that inflexible social policy, Anne was, and I'm quoting the opinion here, utterly bereft of the possibility of total exculpation. Because an innocent life was taken, the duress defense completely failed as a way to get an acquittal on the homicide charge.
This is where the law just gets fascinating because it backs away from that harsh moral line and starts to recognize, human frailty.
Yeah.
So since total duress is out for murder, let's make this unforgettable. Here's a hypothetical. You're on a ledge. A sniper has a rifle aimed at a crowd of 5 people. He tells you to push one innocent bystander off the ledge, or he'll shoot all 5. If you push the one to save the 5, are you legally excused?
No, absolutely not. The policy is just. It's absolute. The law holds that if your only choice is to kill an innocent person to save yourself, or even to save others, the legal burden is on you to find another way, or to sacrifice yourself. It's an incredibly difficult standard.
It's a brutal line to draw.
Right.
Okay, so let's unpack the alternative. If you can't be totally justified, what middle ground is there for someone like Anne Wentworth, who is obviously under extreme coercion?
Okay, so we pivot. We completely shift from justification to mitigation. This idea comes from the doctrine of imperfect duress, and it's analogous to what we see in imperfect self-defense cases. It's not an excuse. It's a recognition that the defendant's mind was so impaired by fear that they didn't have the specific mental state for murder. It reduces the crime, usually from murder down to voluntary manslaughter.
What's the legal thinking behind that? I mean, that's a huge drop in culpability.
Yeah, it is. And legal scholars like Lefebvre and Scott have argued that while the pressure isn't enough to justify the killing, it has to serve to mitigate it. The state of mind of someone killing an innocent person just to save their own life. It's just fundamentally different from a malicious killing. As one scholar put it, that state of mind, while not guiltless, is certainly not malicious.
So this all comes down to that critical legal term, malice aforethought. How does sheer terror cancel out the intent needed for murder?
Malice aforethought is the key. It's the evil intent, that wickedness or conscious disregard for life that defines murder. Imperfect duress basically argues that the extreme coercion overwrites that malice. Your mind isn't focused on premeditation or evil, it's just consumed by a primal survival instinct. And that terror can provide powerful evidence to disprove malice.
So the fear replaces the malice. The person is acting out of terror, not wickedness. And if a jury agrees that malice is gone, the most they can be convicted of is voluntary manslaughter.
Precisely. Manslaughter is homicide without malice. You're still held responsible for the death, but the law recognizes that your moral culpability is significantly less because of the duress.
That shift is the real aha moment. So bringing it back to Anne Wentworth, what was the final conclusion for her with this mitigation doctrine in play?
The court concluded that, based on all the evidence of her extreme fear, she absolutely had a genuine jury issue as to mitigation. So even though duress couldn't get her an acquittal, the facts of that intense coercion were enough that she had the right to have a jury decide if it was murder or if the fear she felt reduced it to manslaughter.
This has been incredibly complex. We went from a general rule to a hard exception and then into this whole separate idea of mitigation. So for our listener, the learner, what is the essential checklist for spotting and analyzing duress and homicide on, say, an exam? We need a clear step-by-step path.
Absolutely. When you see a fact pattern with coercion and a dead body, you have to follow this 5-step diagnostic. If you skip a step, you'll fall into the trap. Step 1, identify the issue. Is there duress at all? An imminent threat of death or serious injury, no reasonable escape. Step 2, check the victim. Critically, was the person killed an innocent third person, not the aggressor? Step 3, total defense check. If the answer to step 2 is YES, you must immediately apply the rule. The defense of duress fails as a complete defense. It's off the table. Stop analyzing total acquittal right there. Step 4, mitigation check. Now you pivot. You analyze the defendant's mental state. Was the pressure so intense, and you can use the Wentworth facts as a model here, that it likely negated malice aforethought? Argue that the terror replaced the evil intent. And finally, step 5, conclusion. If you meet step 4, the outcome is not an acquittal. It's a reduction of the crime from murder to voluntary manslaughter.
That structure is so important because the law sets a clear trap. Our gut says, but the coercion was so real. But the law forces you to honor the innocent victim first. The question has to shift from, was it justified, to was there malice?
Exactly right. You're shifting the entire framework of your argument from legal justification to an assessment of moral culpability.
We've reached the end of this deep dive. We started with this impossible question of when a terrible choice can excuse a crime, and we ended with a really sophisticated legal answer, one that sees both accountability and human frailty.
It really forces us to think about where that line is between criminal fault and just survival instinct. The law won't excuse you for killing an innocent to save yourself, but it does recognize that the terror of that choice fundamentally changes your state of mind. It's a legal acknowledgement that, in the most extreme moments, our survival instinct, while not a justification, is a powerful mitigating force.
A really profound thought to end on. That tension between what the law demands and what humans do under pressure is something you can think about long after this is over. We'll catch you on the next deep dive.